5 seconds. Start. The trial court decreed the suit by judgment dated 31st 12 1985. Stop. Relying on the two sale deeds in favor of plaintiffs, the tax paid receipts, and the oral evidence, it held that plaintiffs were in possession of the suit property from the date of purchase and the defendant had interfered with their possession. Stop. The defendant filed an appeal challenging the judgment and decree of the trial court before the additional district judge. Stop. The first appellate court held that the defendant was in possession of the suit property and the plaintiffs had not made out even prima facie either title or possession over the suit property. Stop. It was of the view that in the circumstances a mere suit for injunction was not maintainable, and at least when the defendant filed his written statement denying the title of plaintiffs and setting up a clear and specific case of title in himself, the plaintiffs ought to have amended the plaint to convert the suit into one for declaration and injunction. Stop. Consequently, it allowed the appeal by judgment and decree dated 9/12 1991 and dismissed the suit. Stop. Being aggrieved, the plaintiffs filed essay number 20 of 1992. Stop. The High Court, by its judgment dated 18/1 1999, allowed the second appeal and restored the judgment and decree of the trial court. Stop. The High Court consequently held that plaintiffs had established their title in regard to the two vacant sites purchased by them and drew an inference that possession was presumed to be with them by applying the principle of possession follows title. Stop. The High Court also held that it was not necessary to plaintiffs to sue for declaration of title, as the question of title could be examined incidental to the question of possession. Stop. The said judgment is challenged by the defendant in this appeal by special leave on the grounds that the suit for permanent injunction without seeking declaration of title was not maintainable on the facts of the case. Stop. At all events, the High Court ought not to have recorded a finding of fact on a serious, disputed, and complicated issues of title in a suit for a mere injunction. Stop. The first appellate court held that plaintiffs had neither established their title nor their possession, and their remedy was to file a suit for declaration and consequential relief. Stop. The High Court in a second appeal ought not to have reversed the said decision of the first appellate court. Stop.